The challenge now is how Islamic law can respond to new things, especially related to change in increasingly modern era. The many problems that have arisen in this modern country, especially after the COVID-19 pandemic, demand the availability of interpretation and effort to discover the law by Islamic jurists. As stated by Yusuf Qardawi, the ever-changing and developing condition of society will of course also give birth to new problems that require answer to their legal status. In this case, ulama have a very important role in actively giving birth to ijtihad as a response to providing solution to various problems faced by Muslim society in today's modern era. There are four objectives of the hybrid teaching collaboration program hosted by the International Program, Undergraduate Study Program in Law, Faculty of Law, Universitas Islam Indonesia, in cooperation with partner universities such as Coventry University. The first one, provide additional perspective on Islamic law and its development. The second one, addressing legal issues regarding the interdisciplinary approach in contemporary Islamic law. The third one, expanding student involvement in addressing ongoing legal problems. And the fourth, as a venue for lecture and student to collaborate and discuss specific issue in Islamic law. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Professor, for the speech. And next is an introduction to International Hybrid Teaching Collaboration Program by the head of Undergraduate Study Program in Law, Bapak Dodi Setiawan, SH, MH, LLM, PhD. And Pak Dodi is also going to be our moderator today to guide us today throughout today's agenda. To Pak Dodi, the time is yours.
Can you unmute, Mr. Dodi?
Oh, sorry. Yeah, thank you. Assalamualaikum warahmatullahi wabarakatuh. Good evening, everybody, and good morning from our partner from Coventry University. The Honorable, and please welcome Associate Professor Ian Williams from Coventry University. Thank you for coming.
Thank you,
And
Mr. Yang.
Thank you.
yeah, thank you for Professor Budi as the Dean of the Faculty of Law, UII, for providing wonderful speech today. And also, ladies and gentlemen, as well as maybe leadership from the study program, also the Faculty of Law in Universitas Islam Indonesia. Today, we would like to have our first hybrid teaching collaboration program 2022, the first day 1. And I would like to give you a short introduction about our program. That hybrid teaching collaboration program is part of the internationalization of the study program in Faculty of Law in Universitas Islam Indonesia. We are learning from our first experience with Coventry University at that time with COIL program, talking about the GSR and how its impact in Indonesia and also in UK and also around the world. And now we are adopting the same pattern with the same event. And now we are raising the issue of Islamic law and how its development. And the hybrid teaching collaboration program is also provides the curriculum and provides students with the opportunity to interact with the international universities and professionals. We are inviting our partners as well as our colleagues from other universities to provide a very different perspective on Islamic law and talking about the topics on how the development of Islamic law around the world. And hybrid teaching collaboration program involves a cross-border collaboration or interaction with people from different backgrounds and cultures, As we see, we also have international students and also participants coming from other than Universitas Islam Indonesia to join our event today just to understand about today our topic is about the interdisciplinary approaches in contemporary Islamic law, and our colleague Associate Professor Ian will talk about the recognition and enforcement of international arbitral award in Middle East country. And right now we also have participants not only the undergraduate study program in law, but also the master program in law. This is the rules of the class because this is the day one. So I would like to give you a very simple rule for this class. In order to receive certificates of this program, the students have to attend minimum 70% of the meetings of the hybrid teaching collaboration program. And participants have to fill the attendance form as part of their performance record in the classroom. So I would like to remind you in the end of this session, there will be an attendance form that you have to fill. And this is part of the obligation for the students that to get the certificate as well. And the hybrid teaching collaboration programs equals to 25 hours study. So it can be converted to one credit system in Universitas Islam Indonesia, especially in the curriculum of undergraduate study program in law. For active participants, you will get a very special gifts for us, and we will announce the active participants in the end of this event. So if you can follow the 4 days of 4 days, actually this is 4 days starting from this Monday to Thursday, and if you can follow all of them and you are raising questions, or maybe you can answer the questions from the speakers, then you can have the right to get special gifts, and the committee will mitigate and write down your names as part of our evaluation to give the gifts for our active participants. And in the day one, actually, we also have one speaker right now, Mr. Associate Professor Ian Williams from Coventry University. He will speak about recognition and enforcement of International Arbitral Award in Middle East country. However, our other speaker, Associate Professor Dr. Ibrahim Najim, the Mufti Consular the Republic of Egypt, basically is he confirmed to us that he is right now in Saudi Arabia, and he should attend some important meetings there as well as doing Umrah, so he couldn't attend for our meeting today. So Ian, you will be the only one speaker for today.
Thank
So
you.
you're welcome. And our second day of hybrid teaching collaboration program, we will have two speakers. The first is Dr. Hamid Di Stefano. However, he just texted me this morning that he got lung attack. So it seems that tomorrow's meeting he will change by Dr. Zaid from International Islamic University of Malaysia. We will pray for Dr. Hamid for hopefully he can get well soon, and the God will provide him speedy recovery. And for the second speaker for our second day will be Mr. Abdurrahman Al-Faqih, SHLLM MA. He is from the Faculty of Law, Universitas Islam Indonesia, and the candidate of PhD in Groningen University. He will speak about the cyber dispute resolution and Islamic law response. The third day of our event, will be also two speakers. The first is Dr. Zaid Muhammad. He will speak about modern Islamic constitutional law. And Mr. Ahmad Zazali, LCMH, he is now in our room today, offline. The interrelationship between religion and state in the contemporary era. So he will speak about that. And the fourth day of our event, we will also have two speakers from our Faculty of Law Universitas Islam Indonesia. The first is Christopher Casson, GD-LLM. He will talk about the Islamic law in the U.S. legal domestic policies. And Mr. Dr. Andes Agus Trianta, MH, MA, PhD, he will talk about the development of Islamic economic law in Indonesia. So this is all the 4 days event details, and hopefully you can follow all of the events. And today as the moderator as well, because today I'm also having 2 positions, introducing you about the event and the other side also becoming the moderator. So today we also have Associate Professor Ian Fox William from the Coventry University. So if you allow me, I would like to read about his CV. So he is currently an associate professor of transnational education and associate head school, global engagement, Coventry University. And uh, he also visiting professor in legal studies in Chandigarh University in India. He also very active in doing some kind of law conferences and also seminars. So this is a very long CV. So I would like to just simplify about his CV and biography. So actually, in short and in conclusion, his expertise, and he will talk about the recognition and enforcement of international arbitral award in Middle East country. So currently, we also have a special subject in Faculty of Law Universitas Islam Indonesia related to international dispute resolution. And we also talk about that the International Arbitral Award is not final, although we can say that it is final and binding, but sometimes in the application, it should be recognized in other countries by the domestic courts in order to get the enforcement. So today, Mr. Ian will talk about whether the International Arbitral Award could be effective, enforced, and recognized in Middle East country, because since all we understand that they also have special feeders on legal system. So he will talk about that maybe in 20 to 30 minutes. Then we will have a Q&A. But before that, since we will establish our joint degree program in next year, because still undergoing process, maybe Ian, you could also introduce our students about the School of Law, Coventry University. Who knows, maybe some part of them will join the joint degree programs between our law schools. So now the time is yours, Ian.
Thank you, Dodik.
Yeah.
Good morning from Coventry, everyone. I know it's good afternoon over there. As Dodik was saying, Coventry Law School is very pleased to be working with UII, and we are in development of a joint degree program, which would result potentially in law students from UII being able to progress to Coventry Law School. And the benefit of that would be getting an LLB degree, which is recognized throughout the world. And what's very important about any law degree, which I will talk about in the presentation, is developing those lawyerly skills. And on an LLB program, we guarantee students the opportunity to develop critical thinking skills, interpersonal skills, academic skills, all within the area of law. Being someone who has looked at thousands of resumes or CVs, being able to stand out and demonstrate your competence to also be able to apply your legal knowledge, your legal learning to real life situations is highly valued by law firms and employers. So here at the law school, we've been teaching law programs for over 50 years. So we are one of the top universities for international students in the UK, and we're very proud of the opportunities that we offer law students here at Coventry to engage with law firms and also law practitioners. I very much believe that there is little point of pursuing a law degree if all you are going to learn is theory. You also need to be able to apply that into real life as well. So being able to use your law degree in whatever career you go into is very important. And we do teach you those skills to either go into traditional legal practice, but also other careers in which having a law degree gives you an advantage. Dodik, are you able to display my PowerPoint?
Okay, I will display now.
Thank you.
Okay. Should we start with the video first or with the PowerPoint first?
Just with the PowerPoint.
Okay.
So today I wanted to talk to you all about two things. The first thing is about being a lawyer in the 21st century. And the second lecture, or the second part of my presentation, is linked to a lecture I gave to a law school in Saudi Arabia last week about international commercial arbitration and the development of commercial arbitration in the kingdom, and how adherence to both principles of Sharia law and also legal principles have been a great way of development in Saudi Arabia. So there is just the title of the presentation. So next slide, please, Dodik. So there again, the awards that the university has won for internationalization. I'm not going to go through that, but all I'll say is that of all students studying at Coventry University, the majority of students are international. So therefore, that really shows our commitment to a global understanding, for me, of law. Next slide, please, Dodik. So that's just a little bit about me. So I'm in charge of all internationalization in the law school, as I've already mentioned. I've been working with UII now for a long time, and we are looking to launch an international program in 2023. As you can also see from my background, we also have a long-standing partnership with one of the best ranked law schools in China. So we're quite proud of our international partnerships in the law school. You can actually see there what my areas of expertise are. I've been teaching law for over 17 years. I won't bore you and go all through those different areas, but you can see one of my areas is international commercial arbitration. That's what I'm talking about today. I'm currently a student at the University of Cambridge, doing a doctorate in education, and that is also my LinkedIn profile there. Next slide, please, Dodik. So I wanted to start off with something bespoke, something individual to you students at UII. And obviously, I don't know you all yet individually, but I take at face value the reason that you are studying law is to be successful. So I wanted to just spend a couple of slides looking at particular skills, whether academic, bespoke to law, or transferable, that you will need to show. So whether you seek a law career in Indonesia or an international career in law, you will need to be able to demonstrate these skills. And often law students say to me, well, what would you say, sir, is the number one skill? And I always find myself coming back to communication, being able to communicate clearly, whether that's in orally, advocacy, or writing, is essential. But that's essential really in any career. So being able to think not only about law in Indonesia, practice in Indonesia, but also practice internationally. What sort of skills are transferable? What sort of skills will equally apply to any country? And communication is one of those most important things. And being a law student, there is an expectation that you will successfully possess critical thinking skills. Remember, when we work with a client, so when I was in practice and I worked with clients It wasn't their job to know about technical areas of law. They were paying me to be able to interpret and summarize the law in more of a layman's term. So therefore, being able to take complex information and communicate it, present it in a digestible and simple way. Now, being a lawyer in the 21st century means a lot of things. Often students doing a law degree dream of a career in traditional practice. A lot of students might go on to do that. However, there are also alternatives to a traditional law career: banking, finance, working for the government. These are all jobs in which having a law degree and the skills that you develop in a law degree will give you an advantage. I know when I was your age and I was a law student, I would want to be able to present myself in the best way possible. And if that meant me presenting advantages that I believed I had over my peers, then I would do that. Now, more of a development recently in law, and one which I will also talk about when I talk about international commercial arbitration in Saudi Arabia, is ethics. And today, a lawyer should be able to demonstrate that they are committed to doing things in a fair and transparent manner. Now, when becoming a lawyer, we seek to, or we try to act in the best interests of our clients. That is very important. So having a commitment to ethics, ethical thinking, what's right, what's wrong, what's fair, what's transparent is particularly important. And later on in the presentation, I will show you how, for example, the Saudi Center for Commercial Arbitration in Saudi Arabia has incorporated ethics into the code of conduct for arbitrators. Next slide, please, Dodik. So here, one of the most important things that the law school and university does is it helps students, so helps people like you in developing your CV or your resume, because at the end of the day, we all submit an application to a job. The people who are shortlisting for the job will look at your application, look at your CV, and they will decide whether or not to shortlist you for an interview. You need to ensure that your CV is the best possible presentation of you. So here in the law school, we have students involved in charities. We also have a law clinic on campus in Coventry Law School, in which students can volunteer to help individuals perhaps who cannot afford to go directly to a solicitor. All of these things are fantastic and look very impressive on a CV. I know certainly when I am shortlisting students, I will look at their resume to see whether or not they have any additional expertise other than their law degree. I know a law program is very challenging, requires a lot of commitment. However, it's also good if you can show additional extracurricular activities, mooting, debating, arbitration competitions. If you can show additional things on your CV other than to your academic studies, that will look very good. And finally, I would say to any law student that I would hope you have a passion for the law. Otherwise, why are you studying a number of years on a law program? And I know law degrees, law programs are not easy. They are meant to be challenging. They are meant to push you to your intellectual limit. to be able to empower others. When I'm in large lectures, I have students say to me, why did you get into law? And I say, it was to help other people, use my skills to help advise other people. So whatever your reason for getting into a law degree, a law program, I would hope that one of those main reasons is your interest, your passion for the law, your interest, your commitment to want to make a difference. So those are just 5 key skills that I believe lawyers in the 21st century need to be able to show to be successful. Next slide, please, Dodik. So this is the substantive part of my presentation to you, and it is commercial arbitration in Saudi Arabia. Now, Saudi Arabia has gone through a particular change, as we'll talk about, since 2012, in which commercial arbitration is now one of the valid forms of alternative dispute resolution in the kingdom. So before we move on to that, I just wanted to briefly go over what is meant by ADR, or alternative dispute resolution. And in the UK, there is a requirement now on all lawyers that when dealing with a civil dispute, that the parties are offered ADR before going to litigation. And as you probably all know, litigation would mean going to court, where a judge would be involved. ADR, alternative dispute resolution, is a way in which court potentially could be avoided to solve a dispute. So there on that slide, you will particularly see that international commercial arbitration is favoured by the business community. It can help to resolve or deal with disputes far quicker than what going to court can be. And as you all know, for a business, saving time could mean also saving money. Another advantage in arbitration for a business is that proceedings are confidential. And you will know that reputation is very important to a business, to their commercial profits. So therefore, if we have a client who is a business who is about to admit fault and pay an arbitral award to the claimant, then they would prefer that no one knows about this, that it would remain confidential. So in Saudi Arabia, as we'll see, in the Centre for Commercial Arbitration, they also adhere to the principles of confidentiality unless all of the parties agree to that information being disclosed. But equally more importantly, the Centre for Commercial Arbitration in Saudi Arabia, their model law is based on UNCITRAL. And you will know already that UNCITRAL, which provides model law, is the #1 model law in the world for cross-border international commercial arbitration. And as you will see there from that slide, Article 1 of UNCITRAL talks about what is meant by commercial. And I put it to you that commercial is something which attracts a value of money. So say, for example, could be sold or could constitute the reason, the bargaining for a contract. But I'll just say from that slide there that business actors, business parties would want their dispute to be solved as quickly and as straightforward as possible. And international commercial arbitration does allow for that. And as Dodic mentioned before, the problem could be that if a party wins that arbitration, what happens to the arbitral award? Is it as simple as the court putting a rubber stamp on that award and enforcing it? But sometimes that is not always the case. Next slide, please, Dodic. So on there, under Article 1.3 of UNCITRAL, it really talks about what is meant to be cross-border, or what makes an arbitration international. Next slide, please, Dodic. So what was the purpose of UNCITRAL? Well, if I say to you the word harmonization, that means it tries to bring together the laws, or all signatory countries are able to access a system of law that is designed to overcome jurisdictional problems in individual countries. So the model law created by UNCITRAL means that any country that has signed up to UNCITRAL should be able to follow it, should be able to invoke the rules, and should be able to, what should we say, should be able to employ commercial arbitration in their own country. Now, UNCITRAL is not the only form of model law. You have ICC, so that's the International Chamber of Commerce. But as I also mentioned, and will mention in a moment, that Saudi Arabia now also has model law on arbitration. And I put it to you that if Saudi Arabia has designed its model law on the principles of UNCITRAL, that will assume credibility. And you know, as future lawyers, that credibility is very important in law. Next slide, please, Dodic. So in Saudi Arabia, the position before 2012 was precarious. Arbitration was not recognized by the courts. So in the case there, Jardewell International and Emaar Property, you had a case that went to arbitration, but the court refused to enforce the arbitral award. Instead, the court decided to go through the case all over again. And that was rather disadvantageous to the claimant. Remember, arbitration is following a legal process. So therefore, it is expected that at the end of that process, the giving of an arbitral award, when that goes to court, the court will do no more than enforce that award. Obviously, if the award is not Sharia compliant, the court will not enforce it. However, all of the dispute resolution has already gone on between the two parties or more parties. It is the court's job to enforce that award. However, in Saudi Arabia, they were not recognizing arbitration, and the courts were intervening and hearing the dispute all over again. However, from 2012, there was a new arbitration law, a new enforcement law, and in 2016, the Saudi Centre for Commercial Arbitration was set up. So, from 2012, there was a slow but sure, resolute, evolving development of arbitration in the kingdom. However, there was still the potentiality that individual judiciary, so as you know, that means individual judges, might not follow arbitration. The new arbitration law, which was based on UNCITRAL, had brought greater certainty. The enforcement law had given courts greater power to enforce a Sharia compliant award. And also the Prime Minister had set up the Saudi Center for Commercial Arbitration. Bear in mind, that is an independent, not-for-profit organization that is not linked to the government, the legislature, or judiciary in Saudi Arabia. It is fully independent. Next slide, please, Dodik. So these are the advantages or pros and the cons, disadvantages of what I believe the development or the current law of arbitration, international commercial arbitration, is in Saudi Arabia. I'm not going to go through all of that because some of the issues I've already dealt with, but I would put it to you that basing the law in Saudi Arabia on UNCITRAL principles is good. It would promote credibility of the law, but as someone who supports ADR, supports the parties resolving the disputes before going to court litigation, what is more powerful than individuals being able to choose the arbitrators? Now, remember, what's particular in Saudi Arabia and many Islamic countries is that the award must be Sharia compliant. Now, unless the arbitrator is an expert in legal studies, is an expert in Islamic studies, I would always advocate having 3 arbitrators. You might wonder why 3. There is no way you can have an even number, 2 or 4 or 6 arbitrators, because you could still have both sides with an equal number of yes or no votes. However, with an odd number, it means there would always be a majority. And that is the most important thing about having odd numbers of arbitrators. I would always recommend to a client the use of arbitration because the client is able to be involved in the resolution of their dispute. And you will know this already as arbitration students, that arbitration, ADR, mediation, negotiation allows the parties to be involved to a degree in their dispute. However, it does have its limits. Arbitration has its limits. So, for example, arbitration is not suitable for a public law dispute. So that would be a dispute, for example, like criminal law. Arbitration would not be appropriate or suitable for that. It would have to go through the courts of the country. But as I've already mentioned as well, making sure that the arbitral award is Sharia compliant. And as I also mentioned, it would be a good idea that the parties appoint one of the arbitrators who is an expert on Sharia law. Next slide, please, Dodik. So there, you've got some examples of where the law in Saudi Arabia, the model law in Saudi Arabia that can be used for commercial arbitration. There are some very important articles there. So for me, straight away, Article 9, the arbitration must be made in writing. That could be an email, but obviously the party starting arbitral proceedings needs to do it in a systematic and authoritative manner. So according to the model law in Saudi Arabia, Article 9 declares that the starting of arbitral proceedings must be in writing. Also look at Article 13. There must be an odd number of arbitrators for the arbitration to be valid. As I mentioned a moment ago, if you have even numbers, you then run the risk of there not being a majority decision. And that will not really serve the purpose of arbitration. Remember, I said before that the reasons why parties, business parties, particularly commercial parties, go for arbitration is that it is more straightforward and hopefully it is quicker than going through the court process. Next slide, please, Dodik. So there, look, Article 14. The arbitrator must have legal capacity. They must hold a university degree in Sharia or law. So therefore, I would always advise a business party, say, for example, if entering into commercial arbitration in Saudi Arabia, that one of the arbitrators, let's say, for example, one arbitrator would be an expert in Sharia jurisprudence, for example, so Ijtihad. So there, Article 17, it is possible for the parties to remove an arbitrator. Article 30, disclosure, rules of evidence. This is following UNCITRAL. So I would put it to you that this is credible. This law, this model law in Saudi, which is designed by the Saudi Centre for Arbitration, Commercial Arbitration, is based on UNCITRAL. Now look at Article 40. It is expected that from the start of arbitral proceedings, the resolution will take no more than 12 months. And there was a decision recently in Saudi Arabia where the dispute actually went over 12 months. But when the courts looked at the dispute, they found out that one of the parties had been delaying on purpose. They were taking a long time to draw one of their expert witnesses. So the court said, just because you have gone over 12 months does not mean the arbitration process cannot complete. And the courts told both parties to go back to arbitration. Next slide, please, Dodik. As I've mentioned before, as I've taught arbitration around the world, I've practiced arbitration in different countries. One of the positives a client will think of commercial arbitration is confidentiality. And particularly if say, for example, they were the party that was paying the other party money. They want to keep their reputation private. But under the arbitral law in Saudi Arabia, the new arbitration law, unless all parties give their consent for disclosure, it is not possible to disclose what has gone on between the parties. And I had a very interesting debate with law students at a law school in Saudi Arabia last week about there being limited laws on privacy in Saudi Arabia and how something like the arbitration happening in a room with the door closed, no one can know about it, only the people in that room, how really that worked in Saudi Arabia with limited laws on privacy. But I was made aware that one of the laws in Saudi Arabia on intellectual property did actually deal with some issues of privacy. So imagine if you or I were a lawyer and we wanted to know what happened in that particular room in the arbitral proceedings. Unless the parties gave their consent, we would never know. But could I go to the courts to find out that I have a right to know what is going on? A very interesting issue as a lawyer. Next slide, please, Dodik. So what has Saudi Arabia done? Well, today, the most popular commercial arbitral dispute resolution in Saudi Arabia is the Saudi Center for Commercial Arbitration. They have big plans. They want to be the number one, the preferred choice of ADR in the kingdom by 2030. All of their services is inspired by Sharia, so should be Sharia compliant. So therefore, there is a confidence that any clients using SCCA should receive an arbitral award that will be enforced by the courts. Again, they promote confidentiality, but also the phrase I've used there is one-stop shop. Now, SCCA have trained arbitrators. They have facilities. They even have a commercial court that can seek to enforce the arbitral award. So if you or I know nothing about arbitration, you would be able to go to SCCA and they could deal with your dispute from the beginning right to the end. Quite powerful. Next slide, please, Dodik. Now, what I found particularly interesting about the SCCA, that not all arbitral institutions around the world do have. Now, like on the law program here, and I'm sure at UII, you have learned about ethics. Now, SCCA also publishes and has on its website a code of conduct that they expect arbitrators, mediators, clients to abide by. So there on that slide, again, integrity and fairness, I mentioned those words before, but these are all things, all characteristics that an arbitrator must demonstrate. And most importantly, they must not be biased. They must be they must demonstrate impropriety. They must not be biased towards any of the parties. They must apply the law in a fairly and diligent manner. They must build up the trust of the parties and be confidential about it. Again, they've got to show integrity and fairness when showing that the arbitration process is a systematic system. I've already shown you quite a few articles already of the model law in Saudi Arabia, because how will parties get involved in the arbitration process unless they believe in it, unless they have trust in it? Remember, if we go to court, there is no guarantee of the outcome. But at least in arbitration, you have an interest. You have a part to play. You want these proceedings to go well. Next slide, please, Dodik. So in conclusion, prior to 2012, arbitration, commercial arbitration, international arbitration was not seen as very positive in Saudi Arabia. However, from 2012, the new arbitration law, the enforcement law, the creation of the Saudi Center for Commercial Arbitration, wanting to be a leading commercial arbitral center by 2030, shows that in the kingdom, they want investment. They want business investment in the kingdom and to be able to deal with that through commercial arbitration if something goes wrong. Remember, with arbitration, there is always, as Dodik mentioned before, there is always the risk of the arbitral award being enforced by the courts. However, I put it to you, if you followed a systematic process like in arbitration, that should be favourable to the judges unless the award is un-Islamic. And finally, arbitrators have an ethical duty to be professional, be transparent, and most importantly, be unbiased or be impartial between the parties. That's my presentation. Thank you ever so much for listening.
Thank you, Ian.
Thank you.
It was perfect and
Thank you.
so complete for the information about the recognition and enforcement of International Arbitral Award in Middle East countries. Now we have the session of Q&A. We have around 100 and more participants here. If you would like to have questions, please raise your hand. You can use the special button here to raise your hand. And as well as if you would like to ask in Bahasa Indonesia, please also don't worry, just mention about the question in Bahasa Indonesia and I would like to translate it to our speaker today. Anyone wants to raise question? Hello? Yeah, I think before we ask the participants to ask the questions, I also have some important notes to clarify to you. So if the Saudi Arabia also they also have their arbitration center there, is there any international cases, for example, as we see that they make a cooperation with international cooperations company to explore and to conduct some kind of exploitations like joint collaboration on mining industry or something like that? So do they provide any trust to choose the Saudi Arabian Arbitration Center as their forum for dispute settlement?
So the most popular, what can we say, industry in Saudi Arabia at the moment that is using arbitration is the construction industry. And there's about 55% of all disputes in 2021 through the Saudi Centre were construction disputes. What I think is particularly advantageous or good about the Saudi Centre for Commercial Arbitration is that on their website, they have a model clause that can be copied and pasted into commercial contracts. So therefore, as I'm sure you all know, an arbitration clause in the contract would mean that both parties agree, or have a number of parties agree, that should there be a dispute in the contract, that parties would agree to go to arbitration first. That's very important. Now, to answer your question, Dodik, if the kingdom is attracting overseas investment, then equally it would also need those clauses to recognise that the seat of arbitration could be in a different country to Saudi Arabia. So therefore, I think using law like UNCITRAL or law like ICC means that many of the countries around the world would follow those laws. However, in terms of the arbitral awards, of course, you've got the New York Convention, and that can be used to enforce or try to enforce the arbitral award. However, I would always say it is still quite precarious, that last bit, to enforce that award. However, if both parties are willing, then the court should be doing no more than enforcing or rubber stamping that award.
Oh, thank you. Is there anybody wants to raise question?
I think everyone's gone to sleep.
In chat box, probably you can see any question.
Oh yes, we have question here.
Okay.
The name is Afrian Shah Tanjung from
Thank you.
Muhammadiyah Cyber University. Yeah, he cannot address the question directly, but the question is, due to the global business engagement, how the commercial arbitration in Middle East provide equal treatment to those are the parties who in following are not Muslims. Is it possible to adopt a global ethic for business or over international arbitration?
Well, first of all, thank you for your question. What I would say is that by centres, countries developing model law that's based on international, well-known arbitration rules like UNCITRAL or ICC, that will help to increase confidence and credibility in those laws, those rules being used. So international businesses feel more comfortable if they recognize or see international legal rules. So UNCITRAL was created for all signatories to be able to use quite easily. And as you saw in Saudi Arabia, although they weren't a signatory to UNCITRAL, they modeled their own law on UNCITRAL. So that I would argue to you, or I would say to you, that would help to bring about credibility and reliance by international business actors.
Thank you. We also have one student and participant here who raised question. Muhammad Shabil, please.
Good morning, Mr. Ian.
Yeah.
No, good morning.
I appreciate the opportunity. First of all, let me introduce myself. My name is Muhammad Shabil Bayhaqi from Universitas Islam Indonesia. So my question is, when the arbitral awards were rejected by court, so it means that both parties will do over the whole process of the court, right? So is it possible that the process can be shortened when the proof have been prevailed by the arbitration award? Thank you.
Well, Mohammed, thank you for your question. Yes, I mean, obviously, I can only talk really from an international law perspective. Obviously, that will not include every single country. But if both of the parties have come to an agreed resolution, then the court should take that as persuasive evidence to enforce the award. However, we do know that there are examples where courts have decided to go over again the individual evidence provided in an arbitral agreement, and sometimes courts will not enforce the award. Now, a client might say to me, well, is that quite risky if there is a chance that the award will not be enforced? I would say to the client that if model law has been followed in a systematic way, then if the court has not enforced the arbitral award, I would advise them to appeal. Now, it's not always easy to appeal the non-dissemination of an arbitral award. However, remember, in arbitration, it is out of negotiation, mediation, arbitration, it is the most legal out of all three. So therefore, there would be evidence available to the court that an arbitral process has been gone through, evidence was submitted, was listened to, was judged by the arbitrators. So I would hope that the court would enforce the arbitral award because the parties have gone through a systematic approach to getting to that award.
Okay, thank you so much.
Thank you.
Answer my question.
Okay, good. I think we will have one more attendee here. If you would like to raise question, this is your opportunity because we almost need to close our event today. Okay, Miss Naila, please.
Okay, Mr. Ian, I would like to ask one question, and the question is, can bilateral or multilateral relation between Saudi Arabia and Western countries can affect the settlement of dispute through arbitration? And that is my question.
Thank you for your question. As like the previous question, if the law in Saudi Arabia or the model law for arbitration, commercial arbitration, is developed from UNCITRAL. UNCITRAL is #1 in the world, is the world's most famous model law for cross-border commercial arbitration. So if it is modeled on the principles of UNCITRAL, that would make it easier. However, in Saudi Arabia, the arbitral award has to be Sharia compliant, and that might be different in the West. However, it would be possible if both of the parties agreed that the law is dealt with. Say, for example, if it's a company in New York and a company in Riyadh, and they need to resolve a dispute, they might decide that the law in Singapore might govern the arbitral award, or the law in France, or they could both agree the law in Riyadh in Saudi Arabia, or the law in America. It's down to the parties. However, what I've always advised clients is always, if both parties can't agree that neither jurisdiction from those parties ought to hear the arbitration, it should be a neutral third country and adhere to the rules there. But say, for example, English law might have a completely different interpretation of contract law than Nigeria, for example. So therefore, choosing a neutral third country might be the best way to go about it.
Great, thank you. So this is part of the freedom of the contract. So the parties have the freedom to choose their forum for their future dispute settlement, as well as the forum to choose which law should govern the contract.
Yes.
So usually we have to advise the clients to choose the best forum as well as the law. And I think English law and New York law, based on my readings, they are the most advanced legal system to provide assistance for clients, or maybe for international businessmen if they would like to govern in the contract, for international contracts especially. So I think thank you very much for Ian for coming and conducting presentation today. It was perfect and very new for us, and thank you very much for that. And hopefully we can see you offline here in June with your students.
Yes.
Hopefully. Okay. We are looking forward for that as well. And for the students who actively participate in our event today, so please for Shabil and for I do not know the name, is Afrian Shah Tanjung and also Ms. Naila. So please contact directly the committee or with Mas Abil, Sharabil, or Miss Gita in international program to get your special gift. So thank you very much, Ian. Good morning there. I'm so sorry for making you earlier to wake up today just to present in Indonesia virtually, but we will see. We will have you offline maybe in June, so we will have talk more with our students. So thank you very much, everybody. This is the end of our session. So please, for all participants, follow the next session of the hybrid teaching collaboration program. So tomorrow we will start around 1 p.m. Offline in the stage room, East Wing in Faculty of Law UII. Thank you, Professor Budi. You follow this session till the end of the session. Thank you so much. Thank you, everybody. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.